All right. Good morning or good afternoon, everyone. This is Curt Varone.
Brad Pinsky here.
All right. And we're here for another edition of Fire Law Roundup for February 6th of 2023. Brad, go ahead. Take us away.
Okay, well, let's start with the not surprising, but another good holding, which also I'm going to try to stretch beyond this holding, but we're going to start with City of Jacksonville and a federal district court, the lowest level federal court, doesn't mean it's not important, it's just the first of three federal courts, has continued the holdings of two prior cases, one involving the FDNY, which is very well known, the Bay case, but saying that African-American firefighters who have a disease which requires them to, which is better, it's a skin irritation disease, and it's better when they have some growth, is part one, and part two, shaving too close causes severe and painful irritation. And here they sued, saying that it's a discriminatory practice, requiring this to be so close shaven. And, you know, we've seen a couple of these cases, obviously the Bay case, but what the court held, let me start with what the court held and then tell everyone why this happened, I think. So the court has held that, and this is an important standard for this and many other cases on similar or even totally different topics. The court held that when a federal or state, I suppose, regulation, in this case, the federal 1910-134, when the federal regulations prohibit, right, certain conduct or mandate certain conduct, they prohibit beards, they prohibit interference with the seal, and they mandate that you be clean shaven within 24 hours. There would be not even 24 hours of growth. That's what I'll address as the new issue. They said that they held that when a federal regulation requires conduct or prohibits conduct, that compliance with such conduct is not discriminatory. It's a great holding. It's the right holding. Look, I always sympathize, as the case reflects that African Americans are more prone to this skin irritation disease than Caucasians. And so I sympathize, but OSHA has the 1910-134 rule, the clean shaven rule, right? I'm not going to be an interior firefighter right here with my little beard. So I think what is brought on these cases is more adequately reflected in the Bay case, which is that many departments allowed 1 day of growth prior to this and said that kind of stubble didn't interfere with the seal. But 2 or 3 or so years ago, OSHA comes out with a clarifying opinion and says, not anymore. There can't be any growth. In fact, some departments, and this was discussed in the Bay case, some departments require you to shave, 2 or 3 times a day if that's what you need to do. And that was extremely irritating to this condition. Look, it'd be irritating to anybody to have to shave, but that memo, I don't know, Curt, if you've ever seen that, but that memo, it's not mentioned in any case, maybe mentioned the Bay case, the FDNY case, but that caused my phone to ring a lot. And then it was since then when we saw a lot of these cases come back because the departments are changing their policy to say, okay, now even 1 day of growth is not acceptable. And that's as a result of that OSHA opinion letter. So that's what I think is why we're seeing these. But so that's the holding. But I also want to say, move this to marijuana, right? Where we've seen ADA cases that have said at the federal level, listen, we're not going to allow the authorized or certified use of a THC cannabis product. We're not going to allow that. And you, the employer, can discriminate, right? But can legally prohibit someone from using a THC product, even for a medical condition. Why? Because federal law declares it a controlled one substance. So the specific holding of this case that compliance with the federal law regulation is not discriminatory, I think we can take to a lot of different cases. So I just thought it was interesting. It's the right holding. And again, I sympathize with everybody, but it's not shocking, right? What was shocking more so was the Bay case, frankly, where it was the Second Circuit reversed the trial court level. So in the FDNY case, the trial court actually held in favor of the African-American firefighters.
Yeah, but that was a crazy ruling. And I think I don't know if the judge really grasped it. I'm not even sure. He might have even been retired at that point, but he was the chief senior judge. He had been around since the 70s. And I don't think he fully grasped the issues, but because you can't, like, he pointed to the fact that no firefighter has ever been overcome because of the stubble. And he used that as, or over a 3 or 4 year period, no firefighter had, as proof that it's safe to do. And that's like saying, well, I've driven a car for 30 years. I've never gotten in an accident, so therefore I don't really need a seatbelt. I mean, you can't, you leave it to the federal agencies. But I got 2 points I want to make. One is that the solution to those who are upset with this, okay, and I know there's a lot of people who are upset with this. If you're upset with this, the solution is research. Okay, the solution is NIOSH taking another look at this and seeing if the regulation is indeed valid, if it still is valid. Now, the regulation goes back to the 70s and 80s when the seals that we had were different. But I think that another round of research by NIOSH looking at this may give OSHA the information they need to go to a different standard. So if you're truly concerned, if you think that this close-shaven rule is racist or you believe it discriminates against people with disability, the solution is not to rail against the judge, rail against the law. You need some research. We need to figure it out. And then from there, OSHA can change its standards. So that's really, I think, the logical approach to this. The other issue has to do with a case out of DC from back in the, I think it was the mid 2000s. And our friend there, Dennis Rubin, was the chief at the time. And there was a strategic decision that the firefighters in DC challenged the no beard rule. And there was a strategic decision that I think in hindsight was a blunder, but they made the decision, the lawyers made the decision not to argue about positive pressure SCBA as you need to be clean shaven. Because at the time, it was post 9/11, the firefighters and the police officers in the DC area, beyond that, also even in my community in Providence, the police were given suits and negative pressure masks to keep in their patrol cars in the event that they came upon some sort of a terrorist act or whatever. So at the time in DC, all of the police officers and firefighters had these Tyvek suits and negative pressure masks. The attorneys made a strategic decision that our better argument is to argue that you need to be clean shaven because of the negative pressure mass. And so therefore they conceded the positive pressure issue, believing that they were going to prevail on the negative pressure. And, a couple of questions in on, the hearing, and no one has ever had to use the negative pressure mask in the history of the department. Therefore, it was considered to be like a pretext. And you already conceded the positive pressure aspect. They didn't argue OSHA. And, the case was over. So I know that a lot of people say, well, I thought the DC case said, well, you can't rely on the DC case. Okay, there was some legal strategic errors, I think, that were made there. And the better case, I think the Bay case is a good one. Atlanta's kind of dated, but it's a good one. But the Bay case out of FDNY, and now this one out of Jacksonville, Florida, I think are going to be the ones that really kind of set the pace.
And what I like about this, and you've kind of been alluding to, is, this case focused specifically on, look, it's a federal regulation, end of story, as opposed to saying, is the federal regulation reasonable, right? It doesn't matter. It's a federal regulation. So compliance with the federal regulation, rather than trying to unravel it and find if it works or not while the regulation exists. And of course, you can't say you're being discriminated against when you're complying with the federal mandate. It was the right holding, but I liked the way they worded it. I thought Bay kind of went, and I haven't looked at that case for, a half a year or so, but it kind of went more into the, is it reasonable standard versus here, it's a rag, it's over.
Well, we get into the thing that we talk about this in the FLSA class a lot more, but it's deference, judicial deference to federal regulations. and that in theory, we don't want, for example, I like to go to a metaphor to the airline industry and the FAA. We don't want judges deciding the landing patterns and the takeoff patterns out of an airport like JFK. I mean, that's crazy for a judge to go playing around with regulations that could potentially kill someone. And this is the same thing, that the judge has no expertise in this area. OSHA is the federal agency that has expertise in this area. The judge should not be touching that, not looking at whether or not, I mean, if it's clearly unreasonable or, it's arbitrary, there's no reasonable basis for it. That's one thing. Okay. And then there's a standard for that. But we don't want to see in a given case, given the sympathies that can come up in a given case and all that, we don't want federal judges usurping the authority of agencies that have the expertise to develop these regulations. And I think this is a good case upholding that principle.
Absolutely. All right, let's quickly go to Florida for a second, where I'd love to be. It's got to be a lot warmer.
Back to Florida.
What's that?
Two in a row.
Two in a row, right?
Jacksonville, Florida, and now.
Oh yeah, right.
Palm
So we're all over Florida now. I'll stay in Florida. So now we're in Palm Beach County, and look, this is just quick. A former firefighter stole money. He was married to somebody who was on a foundation board, and he started using the money for his own personal stuff.
It's a female firefighter.
I'm sorry, right, which makes sense why she used it for cosmetic surgery. But sunglasses, car improvements. So she stole money. I'm always curious how you find some of these things. Is it because it says firefighter in it?
Some of the search engines that I use to bring me the cases, would bring me that result. So it's a
if it was function. A plumber, would it say former plumber convicted of wire fraud? Probably not.
Yeah, but I think when you put somebody who is in a position like a plumber or a tradesman, not that there's anything wrong with that, but you put them on the board of directors, you may feel a need to have reasonable precautions put in place. But when you have someone like a firefighter, and firefighter, doctor, lawyer, oh boy, you definitely want to have some precautions if you have a lawyer on there. Yeah. But the point being that there are certain professions that have some credibility built into them. And one of the reasons why I chose this case on this particular night had to do with the fact that it's a female. And my friend Kelly Paxton has written a book on this. She's devoted her life to this study of pink collar crime. And we all, I know I did prior to meeting Kelly, I had a sense that a male is more likely to steal from you. And that a female is less likely to steal from you. And what Kelly set me straight, she said, they're roughly equal. They are roughly equal. Now, the man is more likely to rob you, okay, at gunpoint or knife point or, using threats of violence. Whereas the female is more likely to embezzle or steal or whatever. But the point being, and the reason why I hate to, keep banging this drum is that our organizations have to have precautions built into them for accounting and bookkeeping and how our money is being spent, whether it's a volunteer fire company, a labor union, or a charity like this one. We need to have some checks and balances in there so that we're not going to find ourselves the victim of someone who we have no reason to suspect may have this issue.
Yeah, and as you probably know, every year, well, probably at least 3 or 4 times a year, I lecture on theft, and I teach a course mandated by the state controller to fire districts. And as part of that, I teach about theft. And I always am interjecting because I'm using real examples, mostly of New York-based cases.
We don't have to make it up.
You don't have to make it up. God, every week there's a new one, but I'm always saying she, and I will bet of the cases I use, which are, just normal she, here's the 2 things I notice on theft. And I know we're off a little bit on topic, but one is it's 80-20, 80% females, 20% males, but the females are stealing less. The males, at least in my examples, right, are stealing in the millions.
Kelly said that. That's good that you picked that up. And you might want to think about getting Kelly out for your conference, your annual conference. She's former federal auditor, federal examiner, fraud examiner, but great deal of knowledge in this area. But yeah, she said that the males who steal a lot more over a long period of time, whereas you can have women who are in these positions. Usually it might be a treasurer, it might be an administrative assistant, and they're skimming a little bit each week, but maybe over 15, 20, 30 years. Yeah. And they're just taking enough so that it's not noticed, and it's over a longer period of time. So in that, you're absolutely right as far as, you know, what Kelly's relayed to me.
Okay. Okay. So now we have an allegation in Kansas City, Kansas. Right. We have an allegation, just a claim of race discrimination and retaliation. The facts are, you know, somewhat disturbing if true. And again, these are allegations. This is not a case with decided decisions where we know what the judge held the facts are. These are just allegations. So I don't think we ever emphasize that enough, or can't emphasize enough. But here we have an African-American firefighter. Some of this sounds a lot like it did in one of our cases a week or two ago about making it hard to get promoted. And I'll talk about that because it's the exact same allegation. It'll sound familiar to you in a second. So here we have a couple of things. So first we have the firefighter saying, listen, during my employment, they've made it very difficult for me to do certain things. For example, they keep moving me from station to station intentionally, and moving me to stations which have predominantly become Black. And I don't know what the percentages of African Americans are here or not to even discuss that. And they say that has an effect, an intentional effect. One, it makes it harder to get promoted, which is exactly what we heard a week or two ago from somebody. And they say, you know, we don't get to bond. We constantly have to pick up our gear and move it to another station. And so they, you know, he said that's one of the discriminatory things that have happened to him. And he said that there's been negative racist comments. I'm not going to quote him. There was a noose on his locker, which is nothing new. It's other allegations. We've seen it. He said he walked in once and people had a bunch of Nazi paraphernalia. So there's that. But then he also was a witness who testified in a proceeding with an individual named Harris, who was awarded money. And he then claims that the retaliation got worse after the testimony. Well, it was retaliation after he testified, discrimination beforehand, right? And I don't know, frankly, this doesn't matter, but it doesn't look like it was any worse than it was before. And it doesn't need to be, it just allows him to add another cause of action. You know, he said he was disciplined, and I want to point this out. He says he was disciplined for social media posts that didn't violate the social media policy, whereas no white people were. And yet I look and I'm like, I don't see a First Amendment claim here. You would have thought he'd maybe add a First Amendment claim. But, you know, the basic common making bad comments, taking action that results in discriminatory, harmful effects, treating me worse than you would white firefighters. He's got all of those allegations in. And, you know, for those who are listening for the first time, when I say this, don't be offended. This is nothing new. And I say that not like it's no big deal. I'm saying it because how many times have we seen and heard these types of allegations? And you know, just like the woman you're talking about looks at patterns on theft, it's almost, we should look at the same thing on discriminatory conduct, because at this point I'm saying we've seen them do this before, move you to stations. We've seen a noose on a locker. We've heard negative comments. And the problem here is not only that it's happening, the problem here is the allegation that this individual reported it to their lieutenant several times and nothing happened. That's a real problem. I'm not excusing the firefighters for making comments, of course, but once you're promoted to lieutenant, you know, I almost feel like our oaths of office, you know, as you raise your right hand should be, and I'm going to take, you know, allegations of discrimination seriously, of harassment seriously. I'm going to protect my firefighters from everything. because we're constantly seeing lieutenants do nothing, of course, because they're brought up through the ranks.
Well, they feel like they want to be one of the guys, and I've seen it in my career. And every officer wants to be respected by their subordinates and so on. But some officers just take that to a degree that they're no longer really the leader. They're just one of the subordinates.
Yeah,
and that. When we have a problem and they don't step forward to intervene. But again, we don't know.
These are just allegations.
Facts here. I honestly, when I read it, I thought it was a little thin on allegations. I really thought it was thin. The biggest concern here, or one of the biggest concerns, was that he has some sort of sensitivity to light, and that he was ordered to turn the light. I mean, really? I mean, we're going to federal court over something like that, but
he was disciplined as a result of not turning the light on.
Right. And again, if I have a sneaky suspicion that if I talk to the people who are personally involved, we're going to get a different story.
Of course.
So I don't know. Some of the things, some of the complaints that we see, have a little more substantive, factual allegations than this one. I thought this one was a little light, but the retaliation part really makes all of the little tiny things along the way. And I certainly don't mean something like people dressed up, with Nazi symbols or nooses or light. I don't mean that, but those were remote from what he's suing for. And, if I'm defending the city in this, I'm asking that they be struck. They're irrelevant. They happened 10 years ago, 15 years ago. They're irrelevant. What's relevant is the retaliation that he's alleging and the specifics that happened within the EEOC's 300 days or 180 days prior to the claim.
And I'll tell you, the first thing that occurred to me, what I would do one way or the other, if I'm the plaintiff, I'm the defendant, you want to get the facts to how many African-American firefighters are assigned to one of those two stations, because that was a big claim. Sure. And how many are transferred, right? What's the percentage in proportion to the percentage of African-Americans, whites? How many white firefighters are transferred routinely between stations versus black? I mean, that one is easy to prove.
I'll give you another fact pattern here. If you have a 5-person company and all 5 everybody's in, nobody's on vacation, and you have a 4-person company at a different station, but somebody's on vacation, so they're running with 3 and you've got 5, there's going to be a detail. And one of those 5 is going to have to go. So was this one of those situations where they were detailing an extra person to another station? And that's a question. Why is there a need for an extra firefighter at that station? Are they understaffed? They've got to run with 4, but they're starting with 3. Well, you've got an issue at that station. Why aren't they at 4? So that's a whole nother administrative issue.
The choice of who you assign.
Well, it's usually, in my experience, usually done on a rotating basis. Okay, but
doesn't sound like it is here.
But when you have not been a good subordinate, okay, and the officer says, Brad, you're on the road, until you start housework when you're told, and you're going to take all of the details, and those types of things happen. Okay, and it's got nothing to do with race. And I'm not saying I don't know what happened here, but I just, again, there was no allegation that he was transferred to the station for no reason. And if his company had 4 people and he was detailed out and another firefighter was detailed into his spot, that's a different scenario. And I think if I'm writing the complaint, I'm going to include that information in the complaint. And it just sort of glossed over. And when it's like when a client comes in, they tend to just gloss over certain facts that they don't want you to pay attention to. And it just seemed like there was a lot of holes in this complaint, like that. Why was he being detailed? Was it true? He made it sound like it was punishment, but it could be that they had extra people. The other station didn't, so they were going to be detailed over there. So at any rate, we don't know.
Yeah, maybe they don't have enough information yet. Maybe the lawyer's just saying, all I got to do is a prima facie case at this point, leave it for discovery. Maybe he was up against a deadline, so he could only do, a short amount of, who knows? Right. But that's, when it's early on in the case, this is what a lawyer is faced with. And, and people, we've received a comment like, oh, we're being too harsh or not harsh enough on things. When lawsuits come into our desks, it is that impression that you need, right? We need to be asking those questions, making those, kind of making the comments of, is this valid or not valid? And, and what else do we need to know? So when a lawsuit comes across any defense lawyer's desk, the mindset you and I are using is what we say. It seems thin, it doesn't. Is our client telling the truth? Who's lying? You always want to ask these questions. So that's all we're doing now, even though we have no way of getting any answers.
Right. And we don't want to, please don't be reaching out to us with behind the scenes information either. It's better if we can just talk about it without our judgment being clouded. So,
right. It's one thing being an armchair quarterback like we get to be, but to have to take criticism for it, that's where I draw the line.
Criticism is fine. That's, but we don't want to, start taking sides in these cases. So,
right.
Yeah.
Okay. So let's go to Minnesota. It is cold as hell there, so I really don't want to go there now. This is it's just a suit, and I'm probably going to regret saying this, but this thing seems way more thin than you might look at the last one.
I would agree.
Let me summarize it. And frankly, I thought some of the things they alleged ends their case. So a firefighter who's only 60 years old, right? Not that old, but a firefighter who's 60 years old is been facing a lot of, I guess.
Brad, let me just interrupt. I don't think he's a firefighter. I think that may be part of the issue. He was hired.
Oh.
He was hired, and I think he had only worked there a few years, but he's not a firefighter. He was hired as an administrative services manager. So he's like
in the fire department.
Civilian employee, and he's a manager, and he manages the other civilian employees in the front office. That's how I interpreted it. Okay.
Yeah, no, that would make way more sense because they didn't say anything about any operational activities. So that way makes way more sense. So, and effectively what it is he has been, he's resigned. He says he was forced to resign or accept a lower position, right? And he said it's all because of my age and the retaliating against me. But he really makes out in this the employer's side, because he says they eliminated the position, although he says they didn't do it in accordance with the union. That's why I was thinking it was fire, because I wasn't aware of a lot of administrators being unionized.
Oh yeah. The city workers. Oh yeah.
Oh, okay. Even in I guess if he's not high enough, that makes sense in an administrative position. But in any event, so he says, look, they eliminated my position, but they didn't follow the proper process. Now, to me, that's a red herring, because whether they follow the process or not is not the basis of this suit. It's what was the reason for eliminating the position. And the normal law with position elimination is that as long as you didn't fill it with another person performing the same tasks under a different job title, you don't have too much of a leg to stand on. And even where a position has been divided up and given all the responsibilities given out to other employees, that's not a violation as well. That the employer is allowed to do that. So here he says, look, they eliminated the position, but they also gave me an opportunity to go to the lower position, right? The new lower position, and accept the pay. I think he's going to have a very hard time, just on what I read, trying to say this is because of his age. Because again, 60 isn't that old, and as an administrative position, right? And look, if he earned too much, maybe, I suppose that's right, possible, but they changed the position. And, he's like, oh, they asked me, but they weren't sincere about my opinion, or they didn't allow me to participate. None of that matters. It's either a new position or not. It's either they downgraded it or not, but they did give you the chance to take the position. He was offered it, just it makes $20,000 or so less money, or he was given the chance to resign and retire, and he took an early retirement. In a lot of cases, I don't know that this is one of them, but in a lot of cases, you being forced to resign and then accepting the resignation waives your rights to challenge. Now, not maybe under a discrimination case, but normally, like for a violation of due process of my discipline, right? If you resign, that's a big strike against you because you resigned.
Well, then you're gonna make that allegation that it was a constructive discharge or constructive termination. And you've got to show that there was so much pressure put on you that a normal person in that situation would have resigned.
And it's funny, even though this is a little off, it's a very interesting topic, but I have that case now before me. And he has a lawyer, and had a lawyer when he resigned.
You're
and I'm
defending?
like, how is there duress? You had a lawyer.
Yeah, but are you defending? You're defending the fire department?
I'm defending the fire department, not the employee. And the employers had a lawyer the whole time. So I'm like, he could have fought it then.
I think both, as I read the case, I think both of us are regularly in a situation where we get a call from someone. And most of the people call me would be a firefighter, but they call me, maybe they just resigned, maybe they're thinking about resigning, but they're in a situation where they feel they're being treated unfairly and whatever it is. And what I end up doing, and I'm assuming other attorneys do as well, is that we're looking for some sort of a defense to kind of trump what the city is trying to do. And when you fit into a protected class, you raise that flag, and whatever that protected class is. In this case, it's age. Probably he didn't fit into some other protected class. If he didn't fit into the age, if he was under 40, we'd be looking for some other protection for the client. And I guess it's just the way our system is, but in this case they're using age as the sort of shield to protect him from this job action.
Yeah, well, my advice, because I'm sure we're going to get a blog question on it or something, is so people would say, well, if they're trying to force me out, should I quit? Right? My advice is don't accept the resignation, don't quit, let them fire you. Or stay around and let them treat you like crap, because then you at least get a retaliation claim, right? If nothing else. But I think quitting, I'm always going to raise it when I'm defending the fire district, fire department, and I'm going to put you on your heels, saying you quit, you weren't forced out, you were given another choice, you could have accepted it. You resigned.
It wasn't really chump change that he was going to get. I mean, he was at 134,923 a year. And so he would have lost about $18,000 a year and would have had less responsibility, of course. So,
but it's still a significant amount of money that is being paid, right? I mean, I don't know. I think I think downgrading a position is a tough and eliminate, not just eliminated, they downgraded. That's a tough fight for somebody, especially when you're offered the position. So anyway, so we'll see. And then finally, which is really interesting just because it's interesting, is the Type Nichols case, which never has an end. The number of people, I mean, if I got dispatched to this case, right, you regret it from the beginning, just being dispatched in any way involved. But here, 3 Memphis firefighters, now they've been terminated. I'm shocked they were terminated so quickly. Look, all eyes are on Memphis, right? But they're terminated because they were dispatched to respond to somebody, we know who, but who was told was pepper sprayed, right? The dispatch, they say, was that somebody was pepper sprayed. The lieutenant arrives, doesn't get out of the vehicle. I personally don't have a problem with that, but because 2 others did and check them out. But as I'm reading this, the allegations against him, I'm like, boy, that's really thin. I didn't think anything was going to happen yet. Then the fire department comes out and says, no, they've investigated. Of course, they know more than we do, right? And they've determined that the lieutenants and the 2 EMTs, the lieutenant, singular, and the 2 EMTs violated, and I'm quoting, numerous MFD policies and protocols. So they've been terminated. That was pretty darn quick. I'm curious where all the due process was. And, I'm a little shocked, but to say that their investigation led so quickly to termination, there's no, look, there's public outcry as there should be, but boy, you would think these people would want to say, wait a minute.
Yeah, it is. That is a quick investigation and process. So,
and 2 of them are just EMTs. I would have expected the 2 EMTs to be like, oh no, it's a lieutenant who told us this or didn't tell us that, or but again, I don't know what their policies were. I don't really know what happened on scene, but this is kind of shocking, frankly. It seems like the allegation is you didn't provide care quickly enough. But I got to tell you, and I've been there, we've all been there. You pull up on the scene, you've got a lot of lights, a lot of police officer lights, right? And a lot of commotion, and you don't know how quickly to approach. And I'm not defending anything. This is not what I'm doing. I'm just saying, for my responder days, right? I can say, you pull up, you're looking around. Where do I go? Is the scene safe? Is it not? Who do I report to? Lights are distracting. Where's the patient, right? Where, you know, if it was pepper spray, you don't walk into the cloud of the pepper spray. Has it dissipated? Is there just one person, two people? There's a lot of questions that would cause me delay in responding, charging in. I don't know what the delay was. Was it 10 minutes or 10 hours, right? I don't know. But I'm just, all that I take away from this is, wow, that was a quick disciplinary process.
Yeah.
And
I think there was some video. Yeah, I think there was some video, not from bystanders. I think it was body cam footage from the police officers. And from what I understand, there was a lack of concern. Probably the easiest way to explain it. And they arrived on scene, and whether an EMS unit was already dispatched and they were awaiting the arrival, or whether they had to do some sort of an assessment and call for an EMS unit. But bottom line is, there wasn't much in terms of aid provided to the gentleman for somewhere around 6 to 7 minutes, as I understand it. So,
and you know, I've been in that position, and again, I'm not defending anyone, right? I'm doing what you and I always do, is just asking questions, right? And so I'm not defending one side or the other. Nobody should take it that way. But, you know, if I walk up on somebody and they're handcuffed or police are surrounding them, unless they're laying dead in the street and nobody's around them, I'm still looking at the cops to say, is it safe scene? Do you want me to go over and check? You know, it's a crime scene, right? Technically, whether the person's alive or not, or breathing or not, you're still waiting for some instruction. Now, I haven't watched the video. I don't know if that part of the video was public. I did not. I intentionally did not watch the police brutality portion of the video. But I don't know. I have a lot of questions. And I think when you look, the department is the one who said they're guilty, right? So presumably the fire department would defend its people if it thought it should. I don't know where the union is, because again, I don't know how you had such a quick hearing. I mean, that was record time for a disciplinary hearing that results in termination. I don't know if they got hung out to dry or not.
Certainly doesn't seem like they did a full and thorough investigation followed by some sort of a discipline process. So. And
more than that, all three people, from lieutenant to the two EMTs in the back, they should be receiving their own individual counsel, because they all have conflicts, right? So, hey, I was just following orders, the Nuremberg defense, or I was just following, the lieutenant told me to do this or told me that, or this is the information we heard. Oh, I didn't hear that. I heard something else. But here, you know, if you're a union, you should be providing three separate counsels. And any union attorney, if he showed up one for all three, is going to quickly realize there could be 2 or 3 stories here. What the lieutenant said and did, what the EMTs said, did, and understood. So again, and with 3 attorneys involved, or 2 attorneys involved, as there should have been, I'm guessing there wasn't, this would have slowed down a lot, right? There would have been possibly discovery. There would have been a review of protocols and training, the communications. There would have been interviews for everybody in the truck. And how the heck did that happen so fast? That's the part I can't get my head around.
Yeah, I'm looking at the numbers here, and it looks like the EMS, the engine company arrived on scene at 8:41. The EMS unit arrived on scene at 8:55. So that's a 14-minute delay. I recall 6 to 7 minutes that they didn't do anything. So I'm not sure where that came from. I'm sure when they first got there was an initial, is the scene secure, like you suggested, and before you go rushing over to the patient. And so I don't know. I seem to recall, and I can't put my finger on where I got it from, but 6 to 7 minute where nothing was done. But it looks like it's 14 minutes between the time they got on the scene and the time the EMS unit got on the scene. So that is
what was happening, right?
Yeah,
I mean, who knows
exactly.
And if nothing was said over the radio that had any racist tones, right? I mean, they probably didn't get on the phone and said, "Hey, don't use lights and sirens. Take it slow because it's just, you know, a black male."
Yeah, I just can't imagine that it got to that level. But it is concerning to me anyway. It's concerning that the officer didn't bother to get out of the truck. I'm troubled by that. If I'm a supervisor, I'm a shift commander, I'm a battalion chief, and that's one of my engine companies. I've got a concern about that that officer is expected to go, supervise. The firefighters are going to be administering the care, but you've got a lot of you got major police scene there. You've got at least 5 police officers, because that's how many have been charged with murder in this case.
So six now.
Six now. And I don't think that these folks are necessarily out of the woods as far as criminal charges go either. So there's a causation issue that is different for these folks than the police officers. But the reason I bring that up is, especially if they're interviewed after the police have already been charged with murder, there's a potential garrity issue in there in terms of compelling them to answer questions. And that should have delayed the investigation, because you can't just rush through this process. If someone says, I'll answer your questions, but I need to speak to an attorney first, it does. I agree with you that this just seems like a rush to judgment. Not all rush to judgments are wrong. Okay. Just because it's a rush to judgment doesn't mean it's wrong. It just means that it happened awfully quickly.
And then the second part is, if you're advising the city, look, the city's in a lot of trouble because of the police anyway, right? So maybe it doesn't matter that the fire department is also liable. But man, by convicting them and coming out with that statement that they violated numerous policies and protocols, you are really likely subjecting the city to additional lawsuits and losses, because you're admitting a violation and then you're terminating them as a result, right? I don't know what they violated. I would like to see specifically what happened and what was alleged to have been violated. But again, if you're not face to face, right, with the victim, and you don't know it's an African-American male, and maybe it doesn't matter, it's a patient,
it shouldn't matter. It shouldn't matter. You have a patient and you're dispatched to help the patient, and you don't help the patient. That's right.
But the question really is, were you waiting for instructions that the scene is safe? I mean, I can come up with so many reasons why care could be delayed that I just, the rush to judgment. I want to know the facts. I want to know what happened in the vehicle. What did they hear? What did they know? What did they learn? What were they told? What policies did they allegedly violate? I don't know. I mean, did they just sit there for 6 minutes for no reason whatsoever?
Or 14 minutes,
was it in the vehicle for 14 minutes, or they didn't arrive at the scene for 14 minutes?
It looks like they were at the scene at 8:41 p.m. So the ambulance was at the scene at 8:41. I'm sorry, the engine was at the scene at 8:41. The ambulance didn't arrive and start care until 8:55. So that's 14 minutes.
But it was dispatched, right, at 8:46.
So I'm assuming that they got on the scene and then said, yes, we are going to need an EMS unit. And I'm not sure, I can speak from Providence. Usually we dispatch an engine and an EMS unit to something like this, okay? But there are times when we don't have any more EMS units. They're tied up. Maybe we're waiting for mutual aid. Maybe we've got an ambulance clearing the hospital saying, all right, I need another 5 minutes and then I'll be available. So that's not clear. But one of the things that we were looking at when we needed to add more rescues was to dispatch engine companies without an EMS unit and have that first in engine assess the patient and then make a determination. Do we need ALS? Do we need BLS? And that may, again, I'm not 100% sure, but it seems like the ambulance was not dispatched until the fire department got on scene and requested it.
And here's the problem I'm having, just gutturally. I'm not saying this is, or I don't know what happened, but gutturally, unless a police officer walked up and said, stay here, right? And maybe, and I don't know if that's what happened. I'm guessing it's not. Or unless they then walked over, which they didn't, to go to the patient and say, hey, what do you want us to do? Why are they sitting in the vehicle? They had to have a reason for sitting in the vehicle. Was it because they were told, or they didn't get clearance?
Well, only the officer sat, the officer and the driver sat in the vehicle. The two EMTs got out.
Right, and that's kind of my point. Like, I don't know that I have an issue. You send 2 people, go handle it. How many people do you need with the patient? But the allegation of delaying care, what was their motive? Here's what I'm saying. What was anybody's motive for violating policies? Was it motivated by the fact that the police were, there? And it was a scene safety issue? Was it motivated? Look, it wasn't 5 white cops and an African-American male, all right? So it wasn't motivated presumably by the race of the patient. What was the alleged reason for the delay of care? I'm having that problem thinking, why would they know to not get out of the truck, the lieutenant? Why would they? Because I just don't have a problem with sending.
Let me make an educated guess.
Okay.
This is what they normally do.
Yeah.
This is how the officer normally just sits in the truck and lets the worker bees go get bloody or do any of the hard stuff. But that's not right. I don't know if that's a violation of their policies, but I got to tell you, if I'm a battalion chief and I come in on this run and I'm looking over there, I've got 2 firefighters working on a patient and the officer's sitting. I don't know what she's doing. She is on her phone. I don't know what she's doing. I'm going to have a conversation with that. Is not right.
I will tell you, I have the opposite side of this because when I was chief for the 4 years, I would send a BLS ambulance to a BLS call. And the paramedic, who was usually the lieutenant, was like, listen, I'm abandoning the people I want to go. And I said, yeah, but what they're upset about is they want to do their job. And it makes it look like we don't trust them on a BLS call. Now, this is not a BLS call, but so there is a side where you're saying, listen, let them do their job, act like you trust them. They don't need to be supervised on an EMS call, right? It's not crew integrity. You got 2 EMTs. Well, look, they're 2 licensed.
I guess, maybe I just have been doing it in a certain way all of my life. I am dumbfounded why an officer would sit there, and not become, at least you don't necessarily have to be the person putting the blood pressure cuff on and taking the vitals. I understand you're going to stand back, but to sit in the apparatus is troubling.
But look, whatever their policies are, that's what they are, right? Whatever I think the reason they should or shouldn't be, but that's what they are. And if that led to this issue, then that led to this issue or not. And that's the other thing. I mean, would it have mattered if there was a 3rd person there, right? To fire the lieutenant, are you firing him or her over the result or the fact that they didn't get out of the, or is all of this a reaction to how bad the incident was and how nationally public it is? Or is this, we would have fired everybody for the same thing?
Yeah, maybe the termination notice, and I don't have a copy of the termination notice, but possibly the termination letter or whatever the adjudication document is to terminate them. It includes a narrative about that. So
I'd love to know these. And I'm not taking the side of management. I'm not taking the side of the firefighters. Their right is right. But when you start with, this is all done and over with in a couple of weeks, I'm going to question everything here. It's too quick. So anyway, that's it, it for the day.
That's it for another edition of Fire Law Roundup. Thank you, everyone. Please be sure to subscribe if you're not already subscribed. We're closing in on 1,000 subscribers. That's a big number for us when it comes to YouTube. So we appreciate your support. And if you like it, please click like. If you don't, email Brad. So.